Okay.
So, good evening, folks in India, and good morning, good afternoon for people joining from United States and from United Kingdom, Europe. Today, I think we already have like 3 very productive days talking about the foundations of international trade, be it trade in goods, with introduction to the trading system, or subsidies, as Spencer must have like discussed with you all, or like must have told you the nitty-gritties of that. So now today we'll be talking about, and we have Mr. Patrick MACRORY again with us, and thank you, Patrick, for like taking all the burden to teach these important and I would say very like the subjects who made the foundations of international trade. So thank you again, Patrick. So today, if I'm not wrong, we are talking about agriculture and trade-related investment measures, procurement, government procurement, and then custom issues like what are the custom duties and all, valuations, some country of origin marking, trade facilitation. So I think this session is going to be, and both the sessions are going to be very interesting. I myself is really looking forward to the trade facilitation because that's one of the areas where I also work with the government sometimes. So Patrick, over to you. Thank you so much.
Thank you very much. Yes, so the first session this morning, I'm going to try to cover 3 agreements. Agriculture is a difficult agreement, probably the worst drafted agreement of all the Uruguay round agreements, quite difficult to understand. And then we'll look at government procurement, which is a very important area. It's a fairly simple agreement, and in particular of interest to India, which is now an observer. And apparently there's quite a lot of debate in India about whether or not India should join the government procurement agreement, because it's one of those so-called plurilateral agreements where one of well, originally 4 agreements that were optional. For all the other agreements, the ones that we've covered so far, those were, if you were in the WTO, you were subject to all the agreements. They were mandatory, except for these few plurilaterals, of which the most important is government procurement. And then we look at trade-related investment measures. That is literally a 10-minute discussion. It's a very simple agreement. Then after the break, we'll look at some customs issues. I thought I'd start with this quote by Robert Hudak, who was one of the top academics in trade law. He taught here in the United States. And what he said was, in addition to the difficulties posed by the curious structure of the agreement, there are actually several different documents. The text of all its provisions, legally binding or otherwise, is exceedingly complex. Almost every general rule is subject to a number of refinements or exceptions, and most of these cannot be translated without recourse to additional information explaining their purpose and the meaning of special terms. So that's sort of a warning. The concepts actually are very simple, but the actual the implementation of the concept is a lot more difficult. So let me go back to, why isn't this working? Sorry. Okay, so going back to the beginning, and let's talk a little bit of background into the problems with trade. Now, one important thing is that, sorry, getting this up and running. It's just some employment figures. We don't need to go into those, but it's just some background. There were major exceptions in the GATT for agricultural products, and I'll explain why in a moment. Quantitative restrictions were allowed for agricultural products where they were receiving support from the government. So you could limit the amount of imports, so those imports didn't take advantage of the support. Export subsidies on primary products, which of course include agriculture, were allowed under Article 16, whereas they were not allowed on regular. Oh, sorry, I'm having a little technical. There we go. Okay, let's go to slideshow. Yeah. Okay. Thank you. Sorry.
Okay.
All right.
Please sit closer to the mic.
Okay. And domestic support, again, was allowed for agricultural products. We mentioned, I think on the first day, there were several waivers given for subsidies, other programs involving agricultural products. Now, why is this? Well, there are a couple of reasons, I think. One is simply that farmers are much more subject to huge variations in production. You might have disease, you might have weather problems. And so they do, there's a case for making support. And the problem with most farm products, you can't wait till prices go up. If you're making televisions, you can say, right, we'll just hold off. We won't sell yet. We'll keep them in a warehouse. But you can't do that with most agricultural products. They are perishable. You have to sell them at whatever price you can get. So that's reason. The other reason is that in many countries, farmers have a lot of political support. I'm sure that's true in India. I don't know the details, but take the United States. As I'm sure you know, every congressional seat in the House of Representatives is based on population, but not in the Senate. Every state has 2 senators. There are 7 states which have less than 1 million inhabitants. They get 2 senators. California, with I think about 50 million, they get 2 senators. So there's a real bias in the American political system in favor of these small states, which like Iowa, which are basically agricultural producers. Now there will give you an idea of the tariffs on agricultural products. And you can see I've given you both the bound rates and the applied rates. You can see a big difference. We talked about that and the fact that if you have a low applied rate, you can increase your tariff up to the bound rate without any penalty whatsoever. But you can see a big difference. The applied rate is just about twice as high on agricultural products, and the same is true, more than twice as high for on the bound rates. So big distortion. Just to give you some numbers, in developing countries, the agriculture represents 40% of GDP, 35% of exports, and the amount of subsidies given by the developed countries are huge. In 2002, I happen to have that figure, OECD countries gave $318 billion to their farmers. And that's 5 times as much as overseas development assistance. It's incredible. I think somebody worked out that every cow in the United States gets $2 from the government, I suppose, not per day. And as we've seen, huge difference, and lots of other numbers like that. There's an enormous disparity. So what happened? Well, Europe, you've probably heard of the common agricultural policy as Europe moved more and more towards a common market. And it was very protectionist, and they had a variable levy, which was really a duty that varied literally day by day. And the duty was set at a level which would mean that all but the marginal supply would be given to Europe. Europe would supply everything it was producing, and then if there was still a shortage, then you would allow imports. French subsidized exports, and you had, as we've seen, very high tariffs. The United States had high target prices based on programs, and you had massive overproduction in Europe, and this is before the Uruguay round. This is in the 80s, really, sort of 70s and 80s. Europe was a net importer of wheat, 25 million metric tons, and went to net exporter. In the United States in the 70s, added 100 million acres to production, and large countries, geographically large countries with relatively small populations, like Australia, Brazil, and they expanded production. And you had the Green Revolution, which basically much more production. So you had a tremendous overproduction. And of course, what did that lead to? Lower prices. Then, sort of in the 80s, developing world economies slowed down. You had this oversupply. There were references in Europe to the butter mountains and wine lakes, just enormous amount. And you can see how much money during the negotiation of the Uruguay round, huge amounts of subsidies, quotas were leading to really higher prices for farmers. And 1901, 220 billion. And remember, that's 1991 dollars, probably more like between 300 and 400 billion today. So something really had to be done. And the plan was to try to deal with these very serious issues, serious budgetary problems. And the Punta del Este Declaration, Punta del Este was where the decision was made by the GATT to begin the Uruguay round negotiations. That's why it's called Punta del Este, obviously. 4 pillars, basically: reduce or eliminate export subsidies, discipline domestic support, not to get rid of it, but at least to try to put some discipline and increase market access opportunities to make it easier to export to other countries, to lower tariffs, to lower quotas, etc. And then, as I think I said, in terms of the rise of anti-dumping and countervailing duty cases on the part of developing countries, that when you start lowering tariffs, countries look for other ways of restricting imports because they may be getting a lot of political pressure from their domestic industries. And the concern was that SPS is, we'll look at that in detail tomorrow, sanitary and phytosanitary measures. Those are measures designed to make sure that food, drink, and so forth coming in is safe, that it isn't full of chemicals and safe to eat. And the concern was that countries would really almost fake SPS measures as a way of restricting imports, even if there was no justification for it. And because it's very complicated, it's very scientific. I'll give you an example. I was in Uganda a number of years ago, and all of a sudden, the European Union banned the import of fish, which were being caught in Lake Victoria. They said there was a cholera risk. Well, that's a difficult thing. How does Uganda, a small country with very little budget, how does it prove that in fact there's no risk? So this was the concern. So the idea was to they were very loosely governed before under the GATT, and now we have a separate agreement on sanitary and phytosanitary, which, as I said, we will look at tomorrow. So we have basically three parts to the, three parts to the agreement. As I mentioned, the SPS agreement is a separate agreement, but designed to make sure countries weren't using SPS measures as disguised form of protection. So market access, let's lower the barriers to imports, reduction of domestic support, and of export subsidies. So let's go through those. I've already read that to you. So market access. Now, we had all kinds of non-tariff barriers, in addition to high tariffs, and very few bindings. Most were simply unbound, so you could raise your tariff to any level you wanted. The US did bind a lot of agricultural tariffs, but other countries not much. I mentioned the EU variable levy, where literally the tariff went up and down day by day, or even I believe sometimes hour by hour, to make sure that imports only got the marginal supply and that the European farmers got the bulk. Canada had what were called supply control quotas. Again, quotas. We mentioned the United States. They had a Section 22 exception, which allowed quotas, and Swiss had restrictions. Japan and Korea had very high tariffs on rice. I think we said Japan is 800%, and then these SPS requirements. So these are the kind of obstacles to trade that the agriculture agreement was intended to address. Now, the agreement did a very interesting thing. We've seen there are lots of non-tariff barriers, quantitative restrictions, variable import levels, import licensing, interest rate, non-tariff barriers through state trading enterprises. And so the idea, and this is a really major achievement, although as we'll see, it didn't work out exactly as it was intended, all non-tariff barriers were to be converted to tariffs. Why? Well, and here are some of the types of any barrier to trade that was not a tariff. There was a QR, quantitative restriction, or a quota. Other types, they all had to be converted to tariffs. There was that one exception for developing country traditional diet. You could still support them. Now, why tariffication? A number of reasons. One is it's much easier to negotiate reductions in tariffs than, say, reductions in or increases in quotas, etc. So it's a simple way. So the idea was that we'll turn everything into tariffs, and as we'll see, they were reduced in the Uruguay round, but the idea was in future negotiating rounds, they would be reduced further. Discipline would be added, and we'll see how that works. They're very transparent. And often tariffs are less trade restrictive than other barriers. A quota is an absolute limit on imports, whereas a tariff is not absolute. If the tariff is not so high as to really block access to the market, then you may be able to sell even with the tariff. You may be able to compete. So least developed countries, and by the way, I'm not sure we mentioned this earlier on, but just as a side note, the WTO and the GATT, there are three categories of country. There are developed countries, which are the, as you can imagine, the OECD countries, etc. There are developing countries, and then there are least developed countries. Now, there's a curiosity, one of the many curiosities about the GATT WTO system. Least developed countries are defined, they use the UN definition, which is basically, a large part of it is GDP per head. I think the figure is about $1,000 at the moment per capita per year.
Excuse me, Patrick?
Yes?
If I could ask you to do two small favors, please.
Yep.
Could you speak a little bit closer to the microphone?
Sure.
I know that's uncomfortable, but if you can. And if you could slightly slow down the pace for clarity.
Okay, sure. I will do my very best. And then developing countries, curious enough, are not defined anywhere in the agreement. And then the developed countries. And it's obvious the developed countries like the United States, or the EU, Canada, etc. But one of the curiosities is that when a country joined the GATT or joins the WTO, it defines itself either as developed or developing. And because, as we will see, there are advantages to being a developing country, the obligations are not as great, every country defines itself when it joins as a developing country. Now, you would think in a sensible system that once a country had reached a certain level of income, that it would graduate to developed countries, but it doesn't. And Hong Kong is still a developing country, so is Singapore and a number of other countries. So it's a real curiosity. Are you hearing me better, Bob?
Yes, much better now. And I'll ask Manoj to help guide the tempo of the discussion.
Okay, so
Sure.
here are the requirements. Least developed countries were not required to reduce their tariffs, but they were required to bind all their agricultural tariffs because most were not bound before the Uruguay round. So now you have a ceiling, if you like, a ceiling binding, and you can't go above that level. But as we've seen, there's a big difference between bound rates and applied rates. And I think we tried to explain that the other day, but if people are still puzzled, let me know, maybe when we get to question time. So developing countries, they had to reduce by 24% on average and at least 10% on each tariff category or each line over a 10-year period. Developed countries, more of an obligation, a 36% reduction, 15% per over 6 years. So you're putting, but no. How did you convert, let's say, a quota? Let's say you had a quota of 50 million tons of wheat, and you have to turn it into a tariff equivalent. What is the equivalent of that 50 million tons of wheat in terms of tariffs? Well, they took a very simple approach. They said, let's suppose that the market price for wheat in the world market price is, making these numbers up, $20 per ton, and the price in the United States is $30 per ton, so $10 higher. Well, what is accounting for that difference in price? Well, it must be the quota. The quota is, because it's limiting the amount of supply, it's going the right price. So there, the tariff equivalent of our 50 million ton quota is 10%. I mean, it's a very simple idea, but unfortunately, I'm sorry, let me move on. There was a lot of cheating, and it's actually known as a dirty tariffication. Countries used artificially high domestic prices and artificially low international prices to mean that you ended up with a high tariff. There was very little oversight. This was all being done towards the end of the Uruguay round. Members didn't really, they did their own calculations, and very often they weren't subject to scrutiny. So we had really a problem. The EU was the worst in this. The tariffs went up, and it was, many economists have estimated the barriers to trade as a result of this tariffication were actually higher in 2000, 5 years into the Uruguay round, than in 1995. It was really, I think, quite shocking. That is one of the reasons I think that there has been this split between developed developing countries and developed. I think the feeling was during the Doha round that the developed countries really had not played it fair. They had not produced the reductions in barriers to trade that everybody had expected. So that's really a very important aspect of the Uruguay round. Okay, I hope that's clear. I know this is a little complicated, but I'm not going to worry about that. Now, there's a special safeguard. We talked about safeguards yesterday, I guess, and there's a special safeguard for agricultural products. Now, it applies, it's very different from the traditional safeguards, the agreement and Article 19 of the GATT. Is based purely on volume. If the volume of imports exceeds a certain level and price, and if it falls below a reference price, then a safeguard is imposed. There's no requirement to show injury, serious injury. It's automatic, basically. So that is quite different. It's been used quite a lot. Okay, so much for barriers, market access. So now domestic support commitments. This gets quite complicated, but I'll try to make it simple, as simple as possible. So again, some numbers. EU was giving enormous support in the form of subsidies, $80 billion farm program, and you had these huge surpluses in the wheat, soybeans, dairy, and meat in the EU. The EU was then selling those surpluses on the world market, pushing prices down and particularly hurting developing countries, which were very dependent on agricultural exports. The main idea, and this is very important, subsidies were disciplined and reduced, but very importantly, subsidies that don't distort trade are not disciplined. So you're free to do what you want. The WTO, they like colors, and I don't think we covered this in subsidies, but there are so-called red light subsidies, which, as you can imagine, are banned, they're bad, and there are green light subsidies, which are okay, and then there are amber subsidies. So we have the same idea of colors in the domestic support. We have the amber box, which is basically subsidies which are assumed to distort trade, and as we discussed yesterday, subsidies do distort trade. Very easy to show that, and so they're considered bad. And the amber box subsidies, as defined by the WTO agreement, are scheduled. So you have to notify the WTO so anybody can find out what the subsidy level is. And again, just like market access, subject to reduction commitments. Blue box, I'm not going to get into detail on this. Blue box, frankly, was a deal between the United States and Europe. In 1991 or 92, while the negotiations, the Uruguay round negotiations were in progress, there was a huge split between them, and the negotiations stopped for a year or two because they were so far apart. And this blue box was designed to really sort of smooth the way to settle the disagreement, and it really allowed certain European subsidies to be permitted. In other words, they would not be banned or subject to commitments. Now, the green box, this is very important. These are subsidies which are not trade distorting and are permitted. There's no requirement to reduce green box subsidies. And so basically, the blue box and green box are defined, and if they're not in those definitions, then they are amber box. So,
Patrick,
yes.
if I could interrupt for a moment to address a couple of questions that have come in. Can you take those now? Okay, so the first question is, has the trade in agriculture reduced in the last decade or so worldwide?
Has it reduced what?
Has trade in agriculture reduced in the last decade or so worldwide?
Ooh, that's a very good question. I frankly don't know the answer offhand. I would guess that it has, as a result of these market access opening and other things achieved by the agriculture agreement. But I don't have figures on that, I'm afraid.
What happens in economies like China, where the economy is itself distorted?
Well, China, when it joined the WTO in 2001, it negotiated its way into the WTO. I think I explained that a country acceding to the WTO has to basically negotiate with any member who wants to negotiate can do so. So the United States, for example, it might want access for American banks into China. So they negotiate. China agrees to allow banks to come in, and we'll look at that when we get to services, I think on Monday. And so in another country, maybe the EU wanted something else. Maybe they wanted access to the auto market, and so they would negotiate with China, and China would lower its tariff on cars, for example. And then everything is put together in what's called a protocol of accession, laying out all the things that China has agreed to do as the price of entering the WTO. Now, to be honest with you, I'm sure there were reductions on tariffs on agriculture, but I don't know what they were. But that, as I said, would be negotiated. I don't think that's been particularly problematic with China. But again, I'm sorry, I don't really know the details. But it's a very good question.
Okay, what do you suppose the difference is? I'm sorry, why do you suppose the difference is so massive between the bound rates and applied rates for agricultural products as compared to industrial products?
That's again, you are asking very good questions. I'm not sure I have a very good answer for it, but I think what's happened is that when in the early days of the GATT and the WTO, but particularly the GATT, most developing countries had high barriers to imports, and of course India is a classic example of that. Very high level of 2,000 quotas, I think, on imports, and then it was changed by was it Prime Minister Singh, I think I'm right in saying, completely changed that, opened up India, and of course it's had a tremendous effect. India is doing well, obviously up and down, but it's done incredibly well compared with what it was before the early 1990s. And what has happened is, I think, economists argue that opening up to trade, even if you do it on a voluntary basis, not as part of negotiation, is going to improve your economy overall. It's going to hurt some people. Some people are going to lose jobs, and obviously farmers in India are, many of them, in great peril. But overall, lower tariffs do produce results. Chile being an example, India being an example, Vietnam. There are many, many examples. And I think I showed you a chart the very first day, showing that countries that had opened up to trade, even if they weren't doing it as part of, let's say, the WTO, the Uruguay round, where you're trading off opportunities, but even on a surely unilateral basis, lowering trade barriers really does improve growth of GDP. And I think what's happened is a lot of countries have realized they had high tariffs, bound tariffs. They didn't reduce much in the negotiations, but they realized that if they open up their markets more on any products, manufacturing or agriculture, people will benefit from it overall. As we said, there are losers, there are winners and losers with open trade. So that is my assumption. And of course, the point about it is a very important point, which people don't pay much attention to. By having a significant difference between your applied rate and your bound rate, you can go up. You can go up to your bound rate if let's say your wheat farmers say, look, we are really in trouble here. There's a lot of imports coming in. We're having a hard time surviving. The country can raise the tariff on imports up to the bound level, and there's no price to pay. With other types of restriction on imports, and we've talked about dumping and safeguards, particularly safeguards, there's a penalty. You have to offer opportunities to other countries to offset the loss of trade. Okay. So that's the best answer I can give you. It's, again, a very good question.
Okay, I've got one question for you, and I'll ask one of Manoj as well. The question, last question for right now is, who decides whether a subsidy falls under amber, blue, or green box? And I'm going to ask Manoj if you could identify the correct Prime Minister, Indian Prime Minister as well.
I did actually at that time. Prime Minister was Mr. P.V. Narasimha Rao, and Finance Minister was Dr. Singh, who
That's right.
later.
Didn't he later become prime
Yeah,
minister?
yeah,
Yeah.
yes,
You're right.
yes,
He was finance minister at the time that the barriers were lowered. Sorry, what was
The
just
question
the
was,
question
who
again?
decides whether a subsidy
Okay.
falls in amber, blue, or green box?
Well, ultimately, the panels and the appellate body when it's functioning, and it's a great question. I mean, basically, a country decides for itself, but then it could be challenged. And one of the biggest, longest-running cases under the agricultural agreement that went to the appellate body was a case Brazil brought against the United States on cotton subsidies. Now, the United States said it's green box. It's not distorting subsidies. Brazil said, no, it's not. It's an amber box. And the appellate body said it's an amber box, and you have gone over your limit for amber box, and therefore you are in violation. So that I hope that's the answer. So the country decides for itself, but if it gets it wrong, then it's subject to dispute settlement.
Okay, and
Okay.
you can proceed. Thank you very much.
All right, thank you. So let's look at a little more detail at there are the famous boxes in color. So the blue box, as I said, this was a deal between Europe and the United States. And we don't need to go into all the details, but there is a definition. It's more detailed in the agreement. Then we have amber box, which are things like price support programs where the government agrees to buy surplus, say, milk off from farmers who can't sell on the market. So they basically set a minimum price, deficiency payments, input investment subsidies, and income support that is coupled to production. We don't need to, you're allowed a certain amount under de minimis. Again, we don't need to go into details. Those are allowed and not subject to reduction commitments. Green box, you can see there, they're not really related to production, research, environmental payments, inspection, food aid, most importantly, decoupled. This is a really important concept. If the government gives a subsidy of, let's say, $1 for every gallon of milk that a farmer produces, what's going to happen to production? It's going to go up because you're getting money from the government. You're getting a subsidy, in essence, from the government. So what if you decouple it? You do not link the amount of support to the production. You link it to maybe historical production, because if you say, well, we'll take your production 2 years ago, that's not going to increase production now because it doesn't make, your current production doesn't make a difference. Very often in Europe, a lot of the EU program, they have decoupled a lot and tried to make it not subject to the agreement. It's based on acreage. So if you have 100 acres of farmland, it doesn't matter what you produce. You could produce nothing, but you still get the same level of subsidy. So it's a very important concept. So I hope that's clear. But more and more countries are trying to decouple because then they can give support. They can give a lot of support. They can give an unlimited amount of support, but it is not encouraging production. Okay, does that concept make sense? Okay, so here we have sort of particular types of payment which fall within the amber box. Remember, blue box and green box are not subject to any restrictions. But for amber box, all the other types of subsidies that are in some way linked to production, there's certain types. They're capped at the average levels in 1986, 1988, and reduction equipment. Again, developed countries have a 20% reduction over 6 years. Developing countries, a lower reduction, longer period. LDCs know that. Now, I'm going to show you what I find strange about this. Basically, this rewards countries which gave very large subsidies, because if they, in 1986, 88, gave large subsidies, then they can continue giving large subsidies. And again, the numbers are really rather shocking. Okay, so just take amber box alone. The average per farmer support is $49. Now, this is maybe a year or two old, but look at the United States, almost 20 times as much as India. And Canada is very high. and the EU is much higher. And then if we take all boxes, the amount of aid given to under green, blue, and amber, again, India is far, far lower than the US. So every farmer, on average, in the United States, is getting $61,000 from the government. It's really, as I said, quite shocking, and it rewards the countries that were the worst subsidizers. But that was what was negotiated. Blue box, again, there's reduction. It isn't subject to reduction commitments. You can go on giving blue dot, and it was designed, as I said, to shield a lot of the EU farm program. Green box, I've got a little bit more on green box. Again, not subject to reduction commitments, measures that don't distort trade, and there again some examples. The decoupling is the most important because countries can do a lot with those. Okay, then we get to export subsidies, the third leg, if you like. And again, just some numbers. France was the worst on export subsidies, 85%. The United States has given some, but not nearly as much. And then other countries that have been doing quite a lot of export support. Now, as we said, they are particularly bad. There are some numbers there. India not being part of that. I honestly don't know how much India is giving, if any. And again, reduction commitments. And you can see numbers look quite similar. Developed countries, 36% reduction in value of exports, which are being subsidized, 20% in volume, etc. Those are fairly clear. Again, LDCs were not required. Now, and important, as you know, the Doha round largely failed, except for the trade facilitation agreement, which we'll look at in a few minutes. But at the Nairobi ministerial, it was agreed that countries would eliminate export subsidies. So that was an important step because export subsidies, as we said, are very distortionary. I've just got one more slide. I mentioned the cotton subsidies case where the US had misclassified one of its subsidy programs. They had said it was green box, and the appellate body said, no, it's not, it's amber box. And because this belongs in the amber box, that takes your total amber box subsidies over the limit. And so you are in violation. And EU sugar, that was brought by Australia, by the way, of course. That was a situation where the EU had gone over its limit on export subsidies. So that's the story on dispute settlement. I'm sorry, on agriculture. So let's move on. Now, does anybody, any more questions on agriculture? As I hope you can see, it's a complicated agreement. The concepts are simple, but the details can be quite difficult to master. Any more questions? I hope not. How do I, let's see, escape? Okay, yeah, no, I know where we go. Thanks. Okay, so let's now look at government procurement. Okay, from current slide. Again, just to re-emphasize, the government procurement agreement, which was negotiated as part of the Uruguay round, was a plurilateral agreement, not binding on all members. And as we'll see, most of the members, most of the signatories to the government procurement agreement are developing countries, but not developed countries. But as I said, important to understand, India is an observer to the agreement. It's sort of watching to see how it works. And there is, I believe, quite a lot of interest in India in joining the agreement. So lots, very high numbers, a lot of trade. Here are some numbers. OECD countries, 20% of gross national product is in the form of government procurement. Governments buying things like computers or chairs or cars for their own use. Somewhat lower for the non-OECD, which is still significant. And again, the size of the contestable market for exports, OECD, $4.7 trillion. That's a lot of money. And a lot of it is in the form of non-central governments. Now, I think we all know the problems with government procurement. It's often very inefficient. You don't get good value for money. There's a lot of overpricing, estimated 20%, maybe higher than it should be. There's quite a lot of corruption because you're talking about huge sums of money. You're talking about dams being built or large purchases. I mean, imagine how many cars the United States government buys every year. That's huge numbers. And that can take quite a lot of different forms, the corruption. For example, you might give bidding information to a particular party who you want to give the bid to. You wait till the last minute, the deadline for bids. You then tell your favored company what the others are bidding, and then they can come in at $1 less. I'm exaggerating, but you see what I mean. Or restrictive specifications. You could say, right, we want to buy pipe, but it must be made of a certain quality of steel and be a certain size. Well, guess what? That happens to be the variety of steel used by a domestic company as opposed to foreign exporters. Often you get different institutions. It's bureaucratic. So lots of problems. Now, again, this is all, I think, very obvious. It often undermines the public confidence, particularly if we've got corruption, waste of public money, huge sums of money are spent on procurement, and often it's, as we've said, very overpriced, and it distorts trade. So, a little history. First of all, members of the GATT, they were very reluctant to open government procurement. They wanted to keep that for their domestic industries. And again, we looked at this on Monday, and I know we've covered a great deal of ground, but you may or may not remember that Article 3, which deals with national treatment, which requires that imports be treated at least as well as domestic-like products. But Article 8A of the GATT excluded government procurement. Basically said governments can do what they want. They don't have to consider foreign bids, or they can discriminate against foreign bids. For example, the United States has a Buy American Act, and it doesn't prohibit foreign bidders from competing for government procurement tenders, but it applies an 8% artificial increase. So let's say a foreign bidder comes in at 100, and the lowest domestic bidder is 104. Well, you would think if the bid was it was based entirely on price, then the foreign bidder would get it. They're $4 below the lowest domestic price. But no, what the US does under Buy America, it adds $6 to the foreign bid. So now the foreign bid is deemed to be higher, 106. Now they don't get 106 if they happen to win the contract, they still get 100. But that is a way of discriminating. So there are other ways of doing it, or requiring, let's say Thailand requires all the bid to be in the Thai language. That might take a lot of time. So the first time that the GATT members decided to try to do something about government procurement, to try to open it up to competition, to allow, to make it easier for foreign companies to bid on government procurement, it produced an agreement called the Government Procurement Agreement in 1979, part of the Tokyo. Now, it was fairly limited. It only applied to goods. It didn't apply to services or construction, etc. It was mostly OECD countries. It had high thresholds, so that if you were talking about a bid of $100,000, it wouldn't be covered. You could discriminate, but where it was a big project, then if you had signed the agreement, you couldn't discriminate. You had to treat the imported bid at the same terms as the domestic bid. Now, here's a very interesting feature, and this goes back to this idea of reciprocity. Remember, we said that the whole idea of lowering trade barriers is to do it on a reciprocal basis, so each country, in very rough terms, is lowering its barriers to roughly the same amount. And this applied to the GPA, the Government Procurement Agreement, because if you think about it, different governments have a different level of procurement. In Europe, for example, where you have mostly nationalized health systems, the government is buying a lot of medicine. In the United States, for example, not nearly as much, because it's basically we have a largely privatized system. So if you opened up, in both cases, you opened up the health market, you would get a big disparity. You get much more trade coming into into Europe in the form of government procurement. So the idea was to try to achieve a very rough balance by deciding and negotiating what entities would be covered. So if you ever are dealing with a government procurement issue, you need to go to the government procurement schedule, which is with the WTO easily accessible, to find out whether the particular government agency that has put out the bid is in fact covered in the schedule. And the only case that has come up in dispute settlement on the government procurement agreement was a case the United States brought against Korea. They put out a bid for an airport. I can't remember where, it wasn't Seoul. And the US said, you're not complying with the government procurement agreement. The United States argued that the entity which was responsible for the airport was covered by Korea's schedule. Korea said, no, no, it's not. It's a different agency, which was outside. And in fact, Korea won the case. But that is the point. You have to see what's covered. In the original agreement, the United States, for example, I think the Department of Transportation was left out. I think NASA was left out. Japan excluded its space agency and so on. So that's the idea. And one of the lessons I hope you are learning from this course is that whenever you're dealing with a trade issue, you need to see what the commitments are, what has been filed with the WTO, what are the bound rates, what are the applied rates, and if it's government procurement, has been very low coverage. You can see 35 billion. I mean, that is not a great deal of money in today's terms, but it was a start. The government procurement agreement was greatly expanded in 1994 as part of the Uruguay round. Construction services were included as well as goods, so you're really expanding now. The monetary thresholds were lowered, so now the agreement applied to more government bids as the and then still mostly OECD, but others were negotiating session, and we'll see what countries in. And then the original agreement didn't cover very few subcentral bodies. What do we mean by that? We mean state governments. We mean government entities like, again, in the United States, the New York Port Authority. They are government bodies, but they're not part of the legislature. And so the idea is going, and now you're talking 1.6 trillion. So you're talking a lot more trade involved. And there were a couple of the basic purpose. First of all, it was designed to make the whole procedure more transparent. So the more transparency you get, the more difficult it is to be corrupt, to do things which are not consistent with competition. And so then also, of course, non-discrimination, that was the key to it, was saying you must now give national treatment where an entity that's covered by the schedule is putting out a bid. You must give the foreign bidders exactly the same rights. You can't discriminate against them. And then procedural fairness. It set out detailed procedural rules governing this, again, to make sure that the system was transparent, and also that it followed rules that were designed to prevent corruption. There are some exceptions. Now, some of those, the first bullet point, you will recognize most of those from, excuse me, Article 20 of the GATT, national security, and Article 21, national security, public morals, human, animal, plant life, etc. And then there's some other ones which obviously have a particular application to government procurement, handicap, prison labor, etc. Again, just to emphasize, plurilateral agreement, it's only binding on signatory countries, and you can see the countries that are now part of the agreement. And as I said, they're mostly developed countries. And then the number of observers, including India. I'm sorry, that should be on the slide. I thought I'd corrected that. But anyway, India is observing. I don't think they're formally negotiating a session, but there's a lot of thought being given in India to joining. I'm very controversial. I'm sure a lot of domestic industry won't like the idea. Again, what are the terms and conditions? National treatment, non-discrimination. That's clear, I think, what that's all about. Then transparent procedures. Specification should be objective. Open bidding is the norm. Standard procedure for submission, and standard bid challenge. So if you lose a bid and you think that something was wrong with the way this it was handled, then you can bring a bid challenge. The country must have a system under which a bid can be challenged. Again, we don't need to go into a lot of detail, but just so that you understand essentially what the purpose of the agreement was, to make it more transparent and to make it fairer.
Patrick, hey,
yes.
Patrick, I'm sorry. Do you have a moment for three quick questions?
Why don't I think this is the last slide. Why don't I finish that and then? Okay. Okay. Revised GPA concluded in 2011. It particularly recognized the fact that a lot of procurement was done electronically. It expanded access. The US got a lot more access in the EU to central government entities. And it now covers 1.7 trillion. So it wasn't a huge increase in coverage, but it was sort of coming to terms with the electronic age. And again, you get similar government procurement provision in many trade agreements. The EU has government procurement provisions within the EU, and US free trade agreements always have a provision on government procurement. Again, even if it's a developing country, it will be required to open up its government procurement market. Okay, so that is government procurement. Now, ready for questions? Bob?
Okay. Yes, so we have a few questions here. What does the concept of minimum support price work as regards to the effect on trade?
Sorry, one more time, please.
What does the concept of a minimum support price work as regards to the effect on trade?
Well, it's going to increase production in the country that's giving the increased support, which may have an effect on imports. It also, with the overproduction, might lead to exports at low prices to other countries. In the cotton case, which I mentioned, where Brazil brought a case against cotton, there were 4 countries I think they were all in West Africa, which were very seriously affected by the very low export prices. And so that would be an example. I don't know if that answers the question. I hope so.
How do reduction commitments work?
Basically, each country is required to lower its support. If it's a domestic support, if it's an amber box, it's not covered by one of the exceptions. They have to reduce by the specified amount. I think it was it 36%, I think, for domestic support. So the numbers, I get confused between the different numbers on tariff reductions and domestic support and export support, export subsidies. But it's specified in the agreement. And so if a country doesn't reduce by the amount that it should, then it could be subject to dispute settlement. Again, going back to the US-Brazil case, the US said this particular program is not covered by the reduction commitments because it's green box, and the WTO said no, it's not green box, so therefore it's amber box. And by including that particular subsidy program, you've gone over your reduction commitments because you were supposed to reduce by X. And in fact, because this program is in the amber box, it's reduced by X -1 or -5, whatever the number is. Okay?
Okay, thank you. What big challenges made in domestic courts, and are there appellate mechanisms? Let me ask that again. Are bid challenges made in domestic courts, and are there any appellate mechanisms?
That's again a great question, and my answer is I can say it depends. It depends. A good lawyer's answer, right? Depends on the structure of the country. In the United States, I know a bit about this. I've worked on a few cases. The initial challenge would be within the agency that's making the purchase. There would be a mechanism to basically appeal the bid and say this was wrong for a number of reasons, and that would be initially. But then, in the United States, you can then go to court. We have a special court called the Court of Appeals for the Federal Circuit, which handles, among other things, challenges to bids. So that under the US system, You start in the agency itself, a special sort of process, and then if you still lose, if you don't persuade the agency that it got it wrong, which is unlikely, agencies will normally stick up for their own people, then you go to court. But I don't know, it's going to depend country by country.
But for the purposes of international law, should the state not be considered as a whole entity and not different levels of responsibility for different scheduled entities?
Well, that's another great question. And to some extent, it depends on the political structure of the country. The commitments in the various agreements, the reduction commitments, it's all the commitments, the tariff levels and so on, are applied and considered at the federal level. In our case. Now, states do a lot of government procurement. They do a lot of things. They pass regulations. You may know that California has much tougher auto emission requirements than other states because Los Angeles in particular has a serious climate problem with exhaust emissions. Under the WTO, most of the agreements apply to the federal government, but the federal government is required to do its best to persuade the state governments to go along, and that's the case in the United States. And as far as I know, there's never been a disagreement between the federal government saying to California, no, you shouldn't be doing this, this violates the GATT agreements, the WTO agreements. Now, India, I'm afraid I don't know nearly as much as I should about India. I hope to learn more, how federal the system is and how much independent power the provinces have. But in other words, the California emission requirement, if a country wanted to challenge that, they could, but they would bring a case against the United States, which in turn is responsible for the actions of its governments. I hope that again answers the question. Anything else?
Thank you.
How do I get out?
And if we need to, we can address that again in the open session.
Sure. How do I get, I thought I hit escape to get out of this.
You're already out.
Oh, all right. Oh, sorry. Yes, I see. Now, very simple agreement, which we're going to look at. It won't take long. I see it's already slightly over time. The agreement on trade-related investment measures. Now, basically, the GATT WTO system does not deal with investment. It deals with trade. It deals with things crossing borders, goods crossing borders, services crossing borders, and then to some extent, quite a lot, intellectual property, which we'll look at next week. So there is this one rather simple agreement, which, as I said, deals with investment measures, but it's really the only one. Now, free trade agreements, on the other hand, so all the US, or virtually all the US free trade agreements and many others do include investment provisions similar to bilateral investment treaties, which we'll be looking at next week. But the GATT WTO, this is really the only provision that deals with investment. Now, just a reminder, going back to day one, let's suppose a government requires a foreign investor to buy at least 50% of its raw materials from domestic sources. And that was an example we gave in Canada, and of course the more recent case against India, which was requiring power producers, solar power producers who wanted to sell to the government, they had to buy a certain percentage of their raw materials domestically. That, I think you would all agree, is a clear violation of national treatment. That's national treatment because you are depriving imports from access to that part of the market that's been carved off. And these are other examples. You can't import more materials. The value of your exports, it's often known as trade balancing. Now that again, if you think about it, it's a ban on imports above a certain quantity. What's that? That's a quota. So that's Article 11 of the GATT. And there's some other examples. Now, it's a very curious agreement because all it says is a trade-related investment that's inconsistent with GATT Article 3, national treatment, or 11 quotas are prohibited. And there it gives some examples in the annex. Now, you might think if they're already illegal under Article 3 or Article 11, why do you have a separate agreement making them illegal again? You can only be punished for one violation. You can't be punished twice over for the same action. The answer is that it was really a matter of transparency and elimination. And as you say, any trim that violates the agreement, and by definition also Article 3 of the GATT or Article 11, it has to be notified within 90 days and it has to be eliminated. And again, different periods depending on your level of development. So that was the idea, that by making it transparent and requiring elimination, you would get rid of a lot of these. That's it. I told you it would be very quick. So let's take a 5-minute break and then we'll go to customs. Thank you very much. Are we ready to go, Manoj?
Yes, absolutely, Robert. Oh, Patrick, sorry.
Okay, good.
Before we start, we have one TRIMS question.
Right.
Why are there different timelines for TRIMS violation notification? Instead, don't you think it would be better for all categories of countries to notify within the same time frame, for example, 90 days, and then have differing timelines for rectification measures?
Well, it's a very good question. I can think of two possible reasons. One is that the Uruguay-Iran, they were trying to go easy on least developed countries because obviously they were countries that needed more help, and so they were given more time. But also, you know, it's a matter of resources. The developed countries have plenty of government officials who can put together the information, and the least developed countries and developing countries had less resources, fewer resources available. I think the reason. I don't know for sure, but that to me it would be a logical reason for giving them more time, because all the other commitments, like as we looked at agriculture, the reduction commitments on tariffs and on subsidies were also geared to the level of development. So I think that was the idea. Look, we're being nice. If we subject least developed countries to the same time limits as the developed countries, people will say that's really unfair. We just don't have the resources. I know I was in one African country and the permanent secretary to the trade ministry didn't have a computer. Well, that's difficult in this day and age, and this is some time ago, but not that long. Okay, so any other questions on what we've done so far?
No, I think we're ready to move into customs. Well,
customs obviously is plays a key role, customs agencies, in international trade. They're at the sharp end, if you like. They're the ones who control imports and indeed exports. They assess and collect tariffs, and we'll look at that in some detail. They enforce import bans, say pornography or endangered species, ivory, for example, or something that infringes an intellectual property right. Again, customs does the enforcement. And it's an area where protection sometimes happens quite a lot. There was a wonderful case in the 1970s. It may have been a rumor, but they said that all videotape recorders, video cassette recorders, VCRs, coming into France, which had a domestic industry, were required to go through Poitiers, a small port. And it was always said there was one elderly customs official. It took them an awful lot of time to get through the paperwork. Now, a couple of important terms when we're talking about tariffs. Most tariffs for most countries are what are called ad valorem, which is simply Latin for of value. So they're expressed as a percentage of the value. Some, for simpler products such as fruit and vegetables, very often they're what are called a specific rate. The tariff rate is not based on a percentage of the value of the good. It's based maybe on the weight or maybe the numbers. And the idea is that for oranges, there's not going to be much difference in the value of an orange. Whereas a car, you go all the way from a very simple Ford to a Rolls Royce. And so there, value is much more significant. And many countries have simple systems with a band, if you like, and countries, often developing countries, they have maybe free on raw materials. On intermediate products, semi-finished, it might be 10%, and the final rate will be 20%. Why? That is known as tariff escalation. And of course, it's designed to create more employment in the importing country. If you're importing raw materials and you're paying no duty, then of course you need to hire people to assemble the product and to complete it. So you see that. So some countries have very simple systems with just, depending on the level of finishing. Some are incredibly complicated. The United States is unbelievably complicated. I might give you one or two examples. For example, can anyone tell me why some types of umbrella in the United States pay 6.5% duty, others 8.2%, and walking 4%? I have no idea why that is. It probably goes back a long way. So let's imagine now that you are a customs official and you have an import shipment, let's say, of computers, and you have to decide how much duty to collect. That's your job. What do you need to know in order to know what the correct amount of the tariff is? In a live class, I would, of course, ask the question, but it's harder for you to do that. Well, there are three things that you need to know. One is, what is it? Is it it's a computer? What is an iPhone, for example? Is that a computer? Is it a telephone? It's a lot of different things. So where does it fit? And as we'll see, there's a very detailed classification list that countries all follow. So that's one thing. Then you need to know, so that will tell you what the tariff rate is. If it's a VCR or whatever it is, you go to the schedule and you find out what the tariff rate is. Then if it's ad valorem, and I think for most countries about 90% of tariffs are ad valorem, a percentage of value, you need to know the value. Otherwise you can't, that's one part of the equation. And then finally, and this has become more and more important, you need to know where it's from. Why? Because as we've seen, most favored nation has got fewer and fewer countries apply that. We have free trade agreements. We have the preference programs like the generalized system of preferences. So we need to know where it comes from. And to give you an example, let us suppose there's an anti-dumping duty, an anti-dumping case against televisions from China, and a high duty. And so the Chinese manufacturer says, okay, well, we'll start manufacturing in Malaysia. But we bring in entirely Chinese parts and we'll just assemble in Malaysia. Is it subject to the dumping duty against China, or is it not? Is it a Chinese product still, because really all you've done is fairly minor assembly operations, or has it now become a Malaysian product? Very important, very difficult question, but kind of interesting in a curious way. Okay. Classification is, why is this? Sorry. Whoops, gone too far. Okay, so what we'll look at this morning is, first of all, duty assessment. And as I've said, there are three different things you need to know when you are assessing duty. Then we'll look briefly at import licensing, pre-shipment inspection, and then trade facilitation, which of course is the agreement reached in the Doha round, the only multilateral agreement that was concluded. Okay. We have something called a harmonized system of tariffs. Before World War II, each country had its own way of classifying goods. One country might just put all citrus fruit under one category. Another might break it out into oranges, lemons, and other types, tangerines, other types. So it was very confusing. It was hard to reconcile different countries' statistics. And so in the the early 1950s, Europe started to develop a uniform system, and this was designed as part of moving towards the European Union. Now, curiously, it's not administered by the WTO, by the World Customs Organization, which is based in Brussels. It was known originally as the Brussels nomenclature. Almost every country, in fact, more than just the WTO members, use it. So we now have completely uniform statistics. It makes it much easier to deal. And every 5 years, it's revised to take account of new things. iPhones, when they first came in, there was no classification for iPhones. You had to decide, as I said, is it a computer? Is it a camera? Is it a recorder? And so you have to decide, and we'll see some of the rules. And the World Customs will give non-binding opinions in disputes, but unlike the WTO, and again, I want to emphasize again and again, the WTO is the only international organization which gives really binding decisions which can be enforced. We'll look at that in some detail. It's not perfect. The WTO doesn't have a police force which can go into a country that's violated a rule and say, shape up or we'll penalize you, but it is somewhat enforceable. Okay, basically we have every item is classified by a number, and we have 4-digit headings, which might be citrus fruit, and then Below that, we have 6-digit headings, which would be oranges, grapefruit, lemons, tangerines, etc. So that's the level. There's some general rules of interpretation, which we'll look at. And countries can go further if they want to than 6 digits. So the international system goes as far as 6 digits, and then a country might want to go further. The United States, for example, might want to break out something into 8 or even 10 digits. We've talked about this. Basically, Uganda has a very simple tariff structure. Mexico, 6 basic rates, again, depending on the type of product. India is a little more complicated. I don't know it in detail, but you seem to have sort of fairly standard on, for example, umbrellas. I think maybe it's 10% on all types of umbrella. But there are additional, as I understand it, there are additional, there's an additional duty besides the basic, a special additional duty and an education assessment. So this makes it somewhat more complicated. We've got these 4 rates. Again, I'm not an expert on Indian customs. That just gives an example of how this works. This is the international system. As you can see, 4 digits is the broad category, and then 6 goes down to individual types. And this is the international system. This is just a head note, which is designed to help customs officials classify things. I'm not going to read that out, and you certainly don't have to read it, but it'll just give you, they're very complicated, very detailed. I'm not going to, well, that's what the US schedule looks like. I'm not going to go through it in detail, but there are 3 rates. The general rate is the most favored nation rate. Then you have special rates, which apply mostly to free trade agreements, and then also preferential. And 2 is the original rate set in 1930. And you can see it's a good example, actually, of how what the GATT has done. In 1930, or indeed in 1947, when the GATT was signed, the US rate on garden umbrellas was 40%. It's now 6.5%, huge reduction. And that's basically what the GATT did through the international, the multilateral negotiating rounds. It's a very good way. Now, supposing you are importing bicycles, and let's suppose the rate on bicycles is, let's say 20%. But to encourage people to assemble bicycles, the duty rate on bicycle parts is only 10%. So the incentive is to bring in the parts, employ somebody to put them together. Now, is the box containing bicycle parts, is that really a bicycle, or is it incomplete or unfinished? And what this basically says, this rule, that even if it's not finished, if it's got the essential character of the article, then is treated as a complete article. So a box containing all the parts of a bicycle, the wheels, the frame, the handlebars, etc., would be treated as an incomplete or unfinished article, and it would be treated as a bicycle. So that's an important thing. And there's some rules set up by an important US case as to how you decide whether the article has the essential character of this. And there's some quite interesting cases, which I will come to in a moment, which involved cars. I'm going to just jump ahead. Now, relevant tariff headings for motor cars, this is US example, is 2.5%. Principally design for transport. But for transport goods, it's 25%. It's 10 times as high. This is a historic, we were retaliating against Europe back in the 1960s. And one of the areas we retaliated was to impose a duty of 25%. And this is really aimed at Volkswagen, which was shipping a lot of trucks. But something called a cab chassis is free. And then parts of assemblies is 3.5% of truck assemblies. So if it's a complete truck, then it's 25%. If it's only a part of a truck, it's 3.5%. And there are some, and again, I'm looking at US cases because I know them better, but the same would apply. Often companies really try very hard, it's known as tariff engineering, to pay the lowest possible duty rate. I don't know if you can see that, the main photograph there, it's something called the Subaru Brat. And it certainly looks like a truck, right? And therefore will be subject to 25% duty. But can you see there are 2 chairs in the truck bed? And so Subaru said, well, not a truck, it's a car. It's got seats in the back. And amazingly enough, they got away with it. So it only paid 22.5%. There are a whole other series of things. Toyota brought in a light truck, but they imported the truck bed separately. And then they attached it when it had come into the United States. And they said, well, it's not a truck, it's a cab chassis. Not surprisingly, the customs service and then the court said, no, it is really an incomplete truck. It took 5 minutes to put the truck bed on and 4 nuts and bolts. So they failed. But that was literally hundreds of millions of dollars, because you can imagine 25% duty on a large volume of trucks. And they went up, they tried to get the Supreme Court. They got to go to the BRAT. We've talked about the Ford Transit. This is a wonderful case. It was made in Turkey, and they put a rear seat into the truck. It was a cheap little seat. Well, I suppose theoretically you could sit in it. It complied with safety requirements. But as soon as they imported the truck and declared it as a car, they said, look, it's got rear seats. Of course it's a car. It's not a truck. Trucks don't have rear seats. As soon as they'd been imported, they ripped out the rear seat, and then they sold it as a truck. Well, they lost that one. They said, look, you're selling it as a truck. This is just a subterfuge. Mercedes went even further, and they produced trucks in Germany, and they were completely finished. They were tested, but then they ripped them apart and imported the parts separately. And they said, look, these are parts of cars. They are parts of trucks, and they only pay, I think it was 3.5%. And sorry, I have something. And they reckon it added 9% to the cost, but they were saving a 25% duty, so it was worthwhile. So this is an example of how countries try to get around high tariffs. And this is a very unusual case because you have such a huge difference in the tariff. So that's classification. I'll tell you one more classification story. You may remember the first Star Wars film, which came out, in the 1970s, Darth Vader did not lift his helmet. And so it wasn't clear what it was. Now, if you can believe it, this is true, the tariff on imports of toys or figurines, which were coming in mostly from China after Star Wars figures, the tariff depends on whether the figurine is primarily humanoid or non-humanoid. God only knows why that is. It's some historic reason. And so the question was, was Darth Vader primarily humanoid or non-humanoid? We didn't know because we couldn't tell. You couldn't see his face. Well, Customs was puzzling over this one, not knowing quite what to do. And they heard that the second Star Wars movie, which is set in production, Darth Vader lifted his helmet. So they went to George Lucas, the director of the film, and said, Mr. Lucas, we've got this terrible problem. We don't know how much tariff, what level of tariff to apply. It might be, it all depends on whether Darth Vader is humanoid or not. So please tell us. And George Lucas said, you think I'm out of my mind? This is the big secret. This is going to get everybody to come and watch the movie. So I think Customs used a bond for a while, but these are some of the issues that can come up. Okay. So that's classification, just to give you some idea. I'm sorry, there's one more important principle, which I should mention. Okay, what if an article falls under 2 or more headings? Let's take a clock radio. Now, the question is, which is the most specific description in the tariff schedules? And let's assume that there's one tariff for clocks and one for radios. Well, they're both specific descriptions, so you can't really distinguish. So then we go to the next level, which is the component that provides its essential character. And again, how do we decide that? That can be very tricky. With a clock radio, is the essential character radio or is it a clock? Now, I have one by my bedside and I wake up to the sound of the radio. So it's acting as a clock by waking me up, but it's also a radio. I listen to it for a while before I get up. So which is it? Not easy to tell, and the customs official have to make these decisions. Now, there's one, fortunately, there is a backup that if you really can't decide, then the last equally applicable heading, which would be the highest number, and I mean, take a desk set. There's no classification for a desk set. It's a pencil, paper, a ruler, and an eraser. Well, which gives it the essential character? Is it paper because that's what you write on? Is it the pencil because that's what you write with? So these are the kind of issues that the customs officials have to deal with all the time. Okay, so let's move along. Valuation, frankly, not very interesting, fairly simple, but GATT Article 7 says the duty should be assessed on the actual value of the imported merchandise, not on merchandise of national origin. Until I think the Tokyo round, the US had a tariff for, I think, for rubber and shoes. It was based on not on the value of the imports, but the value of the nearest equivalent US product, which of course could be very high. And so that was banned by Article 7, but we had an exemption for it. So the actual value, the price at which it's offered for sale, etc. It's complicated. There are 5 bases for valuation. The first being transaction value, and that's the actual price of the price that the exporter is charging the importer. So it's just the contract price. That's easy. All you need to look at is the contract. You don't need to go further. And customs officials far prefer to use this if they can. And I believe in the US, 90% of valuation decisions are based on transaction value. And you see, even if you haven't got the actual goods, you can't use that. You can use identical goods or similar. There's a lot of flexibility. Now, what if, I'm sorry, you include various items like packing costs, selling commissions, etc. You don't need to know all these details, but here they are. Now, what if we go back to the example I used, I think, when we talked about anti-dumping? What if we're dealing with Toyota Toyota Japan selling to Toyota US? Could you use the transaction value? Could you use the price that Toyota US is, sorry, I'm getting it the wrong way around. Toyota Japan is charging Toyota US. Well, that's going to be questionable. There could be reasons why that does not reflect a bargain price, a negotiated price. There might be tax reasons in particular why the price might be higher than it would be in the free market or lower. And so in that case, unless you can demonstrate that the price between Toyota Japan and Toyota US, got it right that time, is not affected by the relationship, then you can use transaction value. But if not, you go to deductive value, which is the selling price to the most unrelated buyer. So that would be where Toyota US is selling to unrelated distributors. Now, you have to back out various, I have that in the next slide. No. And basically the value added after importation. Let's suppose that when it comes in into the United States without a radio, without air conditioning, and then Toyota US adds those features, maybe other features. Well, it shouldn't be charging customs duty on those items because they're not imported. They are US, presumably produced in the United States. And so you take that off. And this is one reason why customs officials don't like using deductive value, because you need to get information from the importer as to how much those items were, and just makes things a lot more complicated. Finally, if you can't for some reason use deductive value or transaction value, then we go to something called computed value, which is basically cost of production and an allowance for profit. I think it's very rarely used here. I suspect it's not used in most countries. Again, now you need an awful lot of information from the importer, and you have to verify to make sure it's accurate and so forth. So you simply need to know it's there, but very rarely used. And as I said, there's a lot of flexibility. If you can't use any of those systems, then you can use reasonable flexibility. And again, we don't need to go into that. I suspect it's very, very rarely used. Now, this is quite important. Prohibited values. There are a number of values that are not allowed. If there are 2 alternative values, you can't use the higher just because of the higher. There may be justification for using it. The price of goods on the domestic market, you can't use that. Price of goods for export to third countries, the minimum customs value. Some countries, they just have a target price. All shoes are valued at $20 and arbitrary fictitious values. So those are no-nos. Now, this is very important. What are the rights of the importer spelled out in the agreement? Well, confidentiality, because obviously if you're dealing with costs, prices, you're dealing with confidential information. Right of appeal, but very importantly, withdraw the goods. Now, supposing you have a situation where customs can't use transaction value, instead they go to deductive value. They need information from the importer about the costs added after importation. And that may take some time. Well, do the goods sit on the warehouse meanwhile? And obviously that's a significant cost to the importer instead of getting it onto the market and selling it. And so the agreement says you must be allowed to withdraw the goods even before the value has been decided. But in order to make sure that customs eventually gets its money, that the importer doesn't go out of business or disappears, then it has to put up a guarantee. These are known as bonds, and they can be obtained from customs brokers, etc. And then some transparency, that you have to have the right to know what the value is and how it was used. Now, this is just fun. I found this somewhere on the internet, and I don't know how well you can read it, but this is actually a custom declaration signed by Buzz Aldrin, Neil Armstrong, and Michael Collins, declaring the importation of moon rocks. I love it. You see, they're going through the forms. I don't think there was any duty. I can't read the. I think it was a zero duty, which is probably good. Now, what's the country of origin? Interesting question. Okay, so rules of origin, and we've mentioned this, very important with the increase of most favored nation free trade agreements, and they're really two non-preferential. Is most favored nation tariffs. They apply quantitative country of origin marking, which we'll look at. Dumping or countervail, because those are based on country by country, so we need to know what's going on. Government procurement, again, has which countries are coming from, so that we can determine whether the agencies are. And for statistics, then we have what are called preferential regional trade agreements and preferential arrangements like GSP. Goods wholly obtained, that's pretty simple. Minerals, for example, if they're mined in Canada and coal is mined in Canada instead of the United States, pretty clear where that comes from. And fish caught in the high seas, how do you decide? Well, the flag of the vessel is, and if we have time, I think we have time, we can see they can be rather misleading. So, for example, let's say Mexico imports iron ore and turns it into steel using Mexican coal. Well, what's the country of origin? Is it the country that produced the iron ore where it was mined, or is it turning into steel? In that case, I think it would be Mexico, because the steel is an important thing. But we look at the different ways. And I should say that the Canadian trade minister once said, rules of origin are very, very complex. You don't want to know about them. They are terrible things to deal with. All right. So if goods are not solely obtained, where there's some intermediate process going on in a country where it's coming in from, but the raw materials or the components came from another country. And again, use the example of China and televisions. China, let's say there's a dumping case or a kind of any duty decision on imports of televisions from China. China might say, right, we'll start assembling these in Malaysia. So they're no longer Chinese origin, they're Malaysian origin. Well, are they or are they not? It depends. It depends on whether or not they've been substantially transformed. That's the term of art. And there are a number of different ways in which that is decided, depending on the agreement, and it can be different forms. A change in name, character, or use. Well, let's suppose Mexico imports steel sheet from Colombia, and in Mexico it's annealed and galvanized, which certainly improves it in some respects, but is that a substantial transformation? Frankly, I don't know the answer to that one, but there was a case where steel rod, which was say 1/2 an inch thick, was heated and drawn out into wire, which was maybe 1/10 of an inch thick. Have you substantially transformed the rod? A US court said, no, you haven't, because you haven't added any materials. It's a simple operation and so on, but it could go the other way. So that's one approach, and it's very subjective, and we'll look at an example of that. Tariff shift. Has the tariff classification of the product been changed as a result of what took place in the intermediate country? It could be an amount of value added. In our GSP program, it's 25% no, 35% value added. So if in the intermediate country, again, Mexico and the US, if you've added at least 35% of value, then that would qualify as a Mexican product. The Israel Free Trade Agreement with the US, again, it uses that. Or sometimes a specified manufacturing or process operation. In the case of machine tools, I think there are 4 sort of major components, and 3 of them under the NAFTA, now USMCA, the US-Mexico-Canada Free Trade Agreement, 3 of them have to be produced in a USMCA country. So lots of different ways. I don't want to get into a lot of detail as to how they work, but none of them really work perfectly. There are problems with all of them. There are also problems. Basically, there's no one size that fits all. There's always going to be issues. Now, the Uruguay round produced an agreement on rules of origin, and the idea was to try to produce uniform rules for non-preferential free trade agreements. GSP, that was left up to the individual countries. If it's an FTA, they negotiate the rules of origin, and they are horrendously complicated. To give you an example, in the US-Mexico-Canada Free Trade Agreement, the rules of origin, and I'm not exaggerating, they take up 200 pages of text, because there's a single rule of origin for every single tariff item. It's unbelievably complicated, and they had to be negotiated while the negotiation was going on. Terribly complicated. Yeah, I'm sorry. Here's the slide, and they mostly change the tariff heading. And we'll look at an example of that in a moment. But sometimes it's that and value added. There has to be a certain percentage of value added, and the US-Mexico-Canada agreement has a new criterion. Cars, of course, are very sensitive. We make them in the United States, but a lot of parts are produced in Mexico, and obviously the concern that parts makers in the United States are losing business to the Mexicans. So, under the USMCA, a certain percentage of the car has to be reduced by people making at least, I think it's maybe $20 an hour, but anyways, specified. The idea is to try to bring production back to the United States. It's the only free trade agreement which contains a provision based on earnings, and USMCA, it only applies to automobiles. But that again, now, just talk about a little mischief that can go on, because you're dealing with very technical, very detailed agreements. Tomato catsup is the official name for ketchup. We all know it as ketchup, but in the tariff schedules it's known as catsup. And the raw material for that is tomato paste. So under the Canada-US Free Trade Agreement, which was the predecessor of NAFTA, NAFTA brought Mexico in, but the original agreement was just US-Canada. If you converted anything from outside Chapter 21 into Chapter 21, that conferred origin. So Canada was importing tomato paste, which is Chapter 20, the first 2 numbers in the HTS number. They were importing it from Chile, I believe, and then turning it into tomato ketchup. So they were converting it from outside Chapter 21 into Chapter 21. And they said, right, that confers origin. Now the catsup is classified as Canadian origin, and it qualifies for duty-free treatment. But NAFTA, which came about 3 or 4 years after, there's a very subtle change. Now conversion from outside Chapter 20, except 2002.90 into Chapter 21 confers origin. So now the operation of converting Chilean tomato paste into ketchup no longer creates a ketchup of Canadian origin. So you can see a very subtle change, but a very important one. You can probably guess who was behind that, who produces an awful lot of tomatoes, or tomatoes, as people here say, Mexico. So clearly Mexico got this change made, and now if Canada wanted to produce Canadian tomato ketchup or catsup, it had to use Mexican tomatoes. So that's, there are many, many other examples, but that's just one of them. Okay.
Patrick?
Yes, sir.
If I could interrupt, we do have a few questions which are building up here. I was wondering if we could take a small break and
yeah, sure.
Okay, so first of all, is there a difference between tariff and customs? If so, what?
No, basically tariff or duty, we've said before, I think that's absolutely synonymous, same term. And that is the amount of money that is assessed on imports and is collected by, it's assessed by the Customs Service and collected by the Customs Service.
Okay. Are sales on the high sea where the bill of lading switches and does not show the real origin of the export cause any issues with rules of origin vis-a-vis customs duties?
Well, yes, I'm sure in many situations the bills of lading do get changed in order to benefit from a more favorable country of origin. I mean, for example, if you excuse me, they're importing, I think of a good example. Well, let's say you're importing something from Brazil, and it's put on a ship to come to the United States, and the bill of lading says Brazil. But then halfway through the voyage, you change the bill of lading to say Mexico. So now it qualifies for duty-free treatment, whereas it wouldn't if it's from Brazil, because we do not have a free trade agreement with Brazil. That might be an example. That would be fraud. I mean, the U.S. Customs, if they found out, would prosecute, and somebody would probably go to jail, because obviously when you supply information to customs, the country of origin, etc., and value, if you lie, then you are subject to criminal penalties. Again, I hope that answers the question.
If an exporter supplier classifies a product as per Chapter 85, however, the importer wants to classify the product under Chapter 80, will the customs officer adopt Chapter 85 or 80? Can the importer challenge the tariff classification at the time of importation?
Again, very, very good questions. The answer is it's the importer who does the classification. What the exporter does would not be relevant. Customs wouldn't look at that, or maybe in very unusual circumstances, but normally it's the importer who files the import declaration, the necessary papers, and I'm sorry, what was the second part of the question?
The second part of the question was, um, okay, can the importer challenge the tariff classification
Yes.
at the time of importation?
Absolutely, yes, and I've done it myself. First of all, if you disagree with the customs classification, you file what's called a protest, and that is dealt with within the customs service. They will, at a level of it's like an appeal, but done by customs. Now, normally, customs, unless the customs office just made a simple mistake, and it might be on valuation, you just might have got the numbers wrong, they will normally uphold what their customs official has done. Then, if you lose the protest, you're the importer and custom doesn't change, then you can go to court. You can go to the Court of International Trade and then the Court of Appeals and ultimately the Supreme Court. I'm not sure that any classification cases have gone there, but so that's the answer. There is quite an elaborate appeal process.
Okay. Do you think this could be the reason, apart from lower production costs, why companies like Apple designs the product in country A and assembles them in country B to avoid anti-dumping duties?
No, I don't think so. I think this is simply the value chain. And that the idea is you do each step of the process in the country where it's most economical to do that. And Apple obviously has found that it's cheapest to buy the parts from different countries, but then assemble them in China because assembly costs are much lower. So I don't think I don't think there have been any dumping cases on Apple products that I'm aware of, and that wouldn't be the reason. But in other cases, in the Apple case, I'm sure. I think I mentioned rather remarkably, I didn't realize this until recently, that more than 50% of trade is now, world trade is in the form of value chains. In other words, shipping intermediate products or raw materials. So it's quite remarkable. But yeah, in most cases, as I understand it, I'm not a businessman, obviously, it's designed to minimize the cost of producing a product by doing whatever you're doing. And assembly in China is obviously a very effective way of, a very inexpensive way of getting the final product.
Okay.
Okay.
Two more questions. On what basis is the percentage of value added determined?
Well, that is one type of rule of origin. And as I think I mentioned, that was the rule in our free trade agreement with Israel. I don't think in any, well, I take that back. And that's just 35% value added. So if you added 35% of value in Israel, maybe you bought silk for India or cotton or cloth. And as long as you add 35% or more, then it is classified as Israeli product and it qualifies for duty-free treatment. The same with generalized system of preferences. If the product was at least 35% added in the country that is qualified for GSP treatment, then again, that would be treated as a product of the intermediate country.
Okay.
Again, okay.
And one additional question. There's a little bit of a text here. So how is origin criteria determined in case of third-party invoicing? For example, manufacturer in company A, sale price is $100. Trader in company or in country B buys from the manufacturer and directly ships to the end buyer in country C for $200. While determining percentage of origin material, will the percentage be determined on the $100 or the $200?
I hate to say this, that's a rather complicated question. Would it be possible to print that out so I could read it?
Yeah, of course.
Yeah,
so essentially,
that would be much easier. Then we'll deal with it when we just finish this presentation.
Right. Essentially, what is I'll sum it up. You buy an apple in United States for, a broker buys an apple in the United States for $1.
Yep.
He then sells it to and ships directly from the United States to France for $2. He's increased. He's put $100 or he's put $1 profit on this. Is the apple priced at the
100 or 200? No, I see.
The $1 or the $2, even though the other thing that's happened in the increase from $1 to $2 is the middleman has increased the price. He hasn't touched it, hasn't added any value to it. He has just brokered the deal between country A, country B, and added, in this case, $1 to the price of that apple.
Well, once again, I'm going to use the great lawyer's answer. It depends. Normally, remember, the first and most used way of valuing is based on the transaction price. So the price, that would be the price at which the exporter is charging the importer. The importer in France is paying $2, so that would normally be the transaction value, and that would apply. So it would be $200. Now, in a very rare situation, as I mentioned, customs can use computed value, which is the cost of production, which would be more like $1, but that would be so unusual, particularly with an apple. In fact, with an apple, it wouldn't even be based on value. It probably would be a specific rate. In other words, it would be so much per apple, but just...
Yeah, the apple is just my,
Yeah. But basically, if it's based on value, it would be the value of the actual import-export transaction, what the middleman is selling to the French importer.
Okay.
Okay.
While we've been talking, we've just had two more squeaking here, so we'll address those real quick, and then we'll finish up with your presentation. Tariff differential is an issue that a country might face if a group of countries are entering into a free trade agreement. How could rules of origin be formulated to avoid this?
Sorry, one more time, please.
Tariff differential is an issue that a country might face if a group of countries are entering into a free trade agreement. How could rules of origin be formulated to avoid this issue?
Sorry, I'm not quite sure what the issue is. Are we talking about a country that is not part of the free trade agreement and therefore doesn't benefit from the lower tariffs?
I'll do this. I will save this question, and when we go into our open period, hopefully that person can address it. Okay. And the last question here is whether loss incurred on a particular product will also be considered as negative profit while determining regional value content.
Well, again, profit isn't normally a factor. Well, to qualify that, these things are quite complicated. But generally speaking, if you get to computed value, the last possible basis for customs value, which, as I said, again, I want to emphasize, very, very rare, then profit is a factor. Now, also, supposing Toyota Japan is selling to Toyota US, and that price, the importer says, well, I'd like to use that price. I think it's a reasonable price. And customs say, well, wait a minute, you're related. How can we be sure that it's a reasonable price? One of the factors where Toyota is trying to demonstrate the price is the profit level. If there's a very high profit level, customers say, no, we can't use that. If it's a very low profit or even a loss, they might say we can't use that. But so that would be the only time the profit might be relevant, or, as I said, using computed value. Okay.
Sure, if we can continue with your presentation.
Yeah. Okay, so just two more issues. Country of origin marking. Many, if not most countries, I'm sure this is true in India, require imported goods to be marked with the country of origin. Why? When I ask this question to classes, they often say, well, so customs can tell where it's from. No, it's nothing to do with that at all, because you could put fake labels on let's say, a shirt. You could say product of Israel, whereas in fact it came from India. The idea, of course, is consumer information. Consumers should have the right to know where imported goods come from. They may not trust imported goods, imported food. They want to know where it came from. Or politically, when I was growing up in England in the 1960s, you did not, if you were a good political liberal, you didn't drink South African sherry because of apartheid. Chile, there were boycotts on products from Chile during the Pinochet regime. So that's it. And basically, this is a simple thing. It just says, look, minimize the difficulties, don't damage the products, and just, if you require marks of origin, make sure it's reasonable. It's not that difficult. Now, there's I think, rather fun case which on marking. A company in New Zealand used vessels flagged with New Zealand, Japan, and former Soviet Union to catch fish in the New Zealand economic exclusion zone. As I'm sure you know, that is I think it's a 200-mile limit. It's way beyond national waters. It's high seas, but New Zealand is the only country that has the right to exploit it, fishing or minerals on the sea floor. So the fish caught by New Zealand, Japan, FSU were landed in New Zealand, and then the heads they were cut off and tails cut off. Then the rest of the fish was sent to Korea, where they were filleted and shipped to the United States. What's the country of origin? Well, the New Zealand company said, look, it's really New Zealand. It's all about New Zealand. It's caught in the economic zone. They landed in New Zealand. And it's a New Zealand company which is doing this. Customs said, no. Caught in the high seas. The economic zone is high seas. It's not New Zealand territory. And therefore, it's a product of the flag of the vessels. Well, we have three flags, New Zealand, Japan. I'm sorry, US is, that was a typo. I did that late at night. The former Soviet Union. Does that tell you much about the fish? Which makes most sense? Well, the court said, actually, you're both wrong. Why? Because the product was substantially transformed in Korea. It was changed from something that looked like a fish. It had scales, it had fins, etc. But after it had been treated in Korea, it was just a piece of white meat. So again, that gives you an idea of how these sometimes are. Now, import licensing, I'm not going to spend any time because we are getting short of time, but often countries require importers to obtain licenses. Often it's products in the United States, is arms, it's alcohol, it's tobacco. And basically, these are just sensible rules saying, look, they shouldn't be used in a way that restricts trade. You should have a reasonable time to apply. And they should be, license should be issued within a short period of time. And again, because I appreciate said we don't have to worry about it. It's only something that applies to very poor countries. I'm sure it's not done in India, but it's really a way of a private company assesses the goods before it's exported to determine the value, classification, etc. Now, trade facilitation. This obviously is very important. Let me just get my notes. I'm sure you're all familiar with the problems with customs. too many documents. I read a few years ago that 40 documents were required with a typical import-export transaction, and 200 data elements. Incredibly complicated, a lot of red tape. Often poorer countries don't have much automation, procedures are inefficient, lack of transparency, and outdated border facilities. For example, in Africa, the border between Rwanda, let's say, and Uganda, when you're shipping from Uganda to Rwanda, you first of all have to go through the Ugandan customs border facilities, and then you have to go to Rwanda. You can imagine, if there's a big backup, how long that takes. And it's been estimated that every day of delay by customs, because you can't get the goods into the country and then sell them, it's equivalent to more than 1% of the value of the goods. So if you have significant delays, then you're really talking about a big chunk of your profit. So originally, this was addressed the Kyoto Convention, not the one we think of in terms of climate, but back in 1974. And again, this was done with the World Customs Organization. And the idea was to simply harmonize customs procedures to make it easier to import and export. It's not rocket science. It's very simple and straightforward. And somebody said it's really the plumbing of international trade. And then there was a revised version. And then in the ministerial in 2013, the WTO now, not the WCO, reached the Trade Facilitation Agreement. And it's pretty much non-controversial, because who can complain with reducing red tape and making it cheaper to import and export? And the potential, if all the provisions were agreed to, if every country complied with all the requirements, you could save $1 trillion a year. You're talking about very serious amounts of money. Now, what the agreement does, there are 37 requirements that members have to comply with. And I've just given some examples. Each country must set up a national trade facilitation committee. This would be a committee made up of officials from customs, obviously, but other agencies, maybe your health ministry, which is dealing with SPS. So that's just to try to make sure it's a single window. So there's one place that you go to deal with everything to do with importation. Inquiry points, again, make it transparent, make it easy for companies that are planning to export to your country, make it easy for them to find out what they need to know. Then pre-arrival processing. This is a very sensible idea. Rather than wait until the goods actually arrive at the importing port, start filing documents ahead of time. Allow people to file 2 weeks ahead of time so that customs can work on the documentation and the assessment of duty. They don't need the physical goods there. They just need the paperwork. So these are examples. There are 37 requirements, all, as I said, fairly non-controversial. But this is the interesting about the agreement. It's the first agreement of its kind. And the idea was to give developing countries, which was recognized, most developed countries were already complying with most of these requirements, if not all of them. And the idea was that each country, each developing country, could put the requirements into 3 categories. First category, A, it will go into effect when the agreement enters into force. In other words, this is what we're already doing. Then this B is we will implement them, but at a later date to be decided by us. We will put that into effect within 5 years, within 2 years, but each country has complete flexibility to decide the date. Third is category C. Well, we'll implement it later, but we need technical assistance. We can't do it by ourselves, so only when we get technical assistance. And so various governments, the OECD governments are giving money. A lot of private companies are giving money. For example, the courier companies, express couriers, Federal Express and the like. This is very important because obviously they need to get stuff through very quickly through customs, and so they're giving money, and freight forwarders and so on. So there's a lot. It's complicated. There are a lot of different agencies involved, but anyway, this is the basic idea. Now, I'm sorry, I have to. Let me just check my notes on this. What I wanted to make the point that India, sorry, it's very hard to read that slide, but anyway, India, I was slightly surprised by this because I don't know much about the Indian situation, but basically India put everything into either category A, already in effect, or category B, which we don't need technical assistance. We'll do it ourselves. And there's a chart showing the, oh God, I'm sorry, it's so hard to read that. But basically those are the timelines, and already 78% of the commitments in the agreement have been, as I understand it, put into effect by India according to this chart. So it's India's moved very fast, and I don't know the exact timelines for the ones that are not yet implemented. But again, as I said, India said, look, we can do this, we don't need help. So that I think is, well, I've got one more slide. Yeah, 72% is category A already in effect, and then blue is category B, 27%, and then says no category C, and everything's been classified. So India's really moved very fast on this, which is obviously a very good thing. So that is the end. I'm 2 minutes over, so I think that I can regard that as de minimis, the 2 minutes. So questions, discussion.
Patrick,
Yeah.
if we could review just a few additional questions.
Of course.
The tariff differential is an issue that a country might face if a group of countries are entering into a free trade agreement. How could rules of origin be formulated? Oh, I think we've already...
I think we covered that, yeah.
In the context of tariff differential question, a country which is part of an FTA, I think this might be part of that same question that's supplemented. What about the products of joint economic zones? How is COO marking done then?
That's another great question. Basically, and they probably vary from country to country, but basically, free economic zones, the product has not come into the country. It is outside the customs territory. It doesn't pay duties. Now, in many cases, the products are exported once they're assembled, and then there's no duty. The duty would only be paid on the country of importation. In other cases, it may be sold into the United States market after it's been assembled in the free trade zone, in which case it would pay duty as completed. Interestingly, a lot of auto companies in the United States use free trade zones, and I will just tell you, I enjoy telling stories. Toyota, about 15 years, 20 years ago, did a joint venture with General Motors in a plant called Fremont, which belonged to GM. It's now actually used by Elon Musk to make Teslas, just as a curiosity. Anyway, there's a lot of difference between what the GM officials all wanted their own dining room, executive dining room. The Toyota people said, no, we all eat together, we're egalitarian. But the GM official for the opening ceremony, which was quite a big deal, there was a lot of jobs, came in a Cadillac. And the Cadillac wouldn't start. And there was a picture the next day in the newspaper of the guy from Toyota under the hood of the Cadillac trying to get it to start. And I thought that was so wonderfully symbolic. Anyway, so much for that. So I hope that, again, trying to answer the question.
Okay, so why don't we do this? Let's take a short 5-minute break. For those who would like to stay on after today's session, we'll open it up. I'm hoping that the person who asked the tariff differential question will stay on. And
okay. Okay, I'm back and ready to any discussion that you'd like to have, any questions I'll try to answer, or any thoughts you have on what we've discussed. We've covered a lot of ground this morning. There just isn't enough time to do everything in detail, but as I think I mentioned before, once the pandemic is over and we can travel again, we'd love to see some of it in Washington.
Absolutely, Patrick. And on those lines, I think me and Bob had the discussion earlier that once things get back to normal, and if you know that we regularly visit DC with a delegation in October or November, I specifically choose those months because of the General Assembly also. So I try to make the people sit at the UN and meet with the people during General Assembly. So we'll try to chalk something out if things get back to normal next year. So people, please look out for that, for a delegation that will be visiting New York, Washington, DC, and other cities. So about the open session, open session. May I request all of you to raise your hands, and I'll moderate the session. And right now I can see Ashwin's and Athar's hand being raised. So Ashwin, you please go ahead.
Yeah. Hello, everyone. Good evening and good morning, sir. So my question, myself, Ashwin from India. My question, sir, is in case the supplier connives with the importer in giving a fake country of origin certificate, can the customs officer of the importing country sue the supplier located in the exporting country?
I'm sorry, can they do what to the supplier? Can they get in touch with, or?
As in case my question is, in case the supplier connives with the importer in giving a fake country of origin certificate, can the customs officer of the importing country, can he sue the supplier located in the exporting country? Does he have the jurisdiction and the power to?
No, I mean, I've never run into that situation, but I can't imagine. I mean, let's say you have a product coming from Vietnam into the United States. I think what you're saying is, would the U.S. customs official have jurisdiction over the Vietnamese company? And the answer, in my view, is absolutely not, because the Vietnamese company is not doing business in the United States, and it's not subject to U.S. jurisdiction. I think, does that answer the question?
Partly, sir, in the sense that, but the question is that in case the country of origin certificate in itself is not the correct one, it's not the genuine one. It's maybe it's tampered, or it's the supplier has actually connived with the importer here in US. Like, let's say the Vietnam supplier has, let's say he has connived with the US importer, and the end result is the country of origin certificate is not original. In such a scenario, while giving the benefit or something, when they review the documents, the customs officer sitting in US customs office, can he actually take any charges, or can he impose any restrictions on the Vietnam supplier, or is it just that the country of origin certificate would not be correct? In that scenario, it would be held as invalid.
Yeah, I think, and this is a little bit, well, I could say above my pay grade. I've not run into this situation, but I would think that the only jurisdiction that the U.S. customs would have is over the importer, because they are actually in the United States, and they would be, certainly if they'd been conniving with the Vietnamese exporter to produce a fake certificate of origin, then the importer would be liable of supplying false information to customs.
Yeah, sir. Thank you.
Mm-hmm.
Athar, you can go ahead. Ashwin, please mute your mic.
Yeah.
Thank you.
Thank you for the opportunity. So my question, it's not a question, it's more of a general comment, actually. First of all, I've loved the course until now, so thank you so much for taking time out and teaching this and organizing this. Secondly, what we have covered today is quite a lot, and as you mentioned, sir, we couldn't go in a lot of detail. So I just wanted to know, is there any case, like, are there any cases that you would want us to read to understand both the agreement on agriculture as well as the issues of customs in more detail, either cases or any books or papers that you would recommend we read?
Oh my goodness. There is so much material. I think I mentioned when I started working in this field nearly 50 years ago, there was almost nothing in writing. They didn't teach it at law school. Now there is so much material. I once was doing something, I was looking for economic articles about trade about 5 years ago. I think I found 600 articles just by economists on trade. It's become such an important issue. One of I think you'll be getting, if you haven't already, some of the PowerPoints, and one of I think my first PowerPoint, but you'll be getting copies, I think Manoj will be circulating those, does list some sources, a couple of textbooks which are quite good, and various sources. There are a number of think tanks in Washington, in Europe, and I know in India too, which are producing, people produce many articles about trade. I mean, there is a mass. All you have to do is Google and you'll find endless articles. What I'm trying to remember, we distributed some materials, some background materials through Manoj, and I can't remember if we had anything on agriculture. And I might mention, it's important, a lot of these are produced by the U.S. Congressional Research Service. And that is, it's, we have Congress is behind it, it's probably protectionist, but actually the Congressional Research Service is designed to supply information to congressmen, government officials, and it's absolutely objective, it's neutral, and they often provide very good summaries, often quite short, 2 or 3 pages, but they summarize it. Absolutely no, completely objective, no bias one way or the other. And certainly, I know that we sent to manage a number of materials. I will check to see what we sent, and I can probably, if we haven't got anything on agriculture, I'll absolutely try to find. I'm sure I can find something that we can circulate.
Patrick, you did send a lot of material, and I'm not sure because I didn't really looked at all the material. I just forwarded it to the team, the events team, and I'm sure they have forwarded it to all the participants.
Okay.
So if you find something that could be beneficial for the participants, please do share it with me.
Absolutely. Absolutely.
Just an update to attendees, and I should have given it before. And Patrick also knows that one of my colleagues, Sanya Reed-Smith from Geneva, she'll be also joining us as a speaker on 25th of November. She's fantastic, and she represents mostly developing and underdeveloped nations. So it would be good to have a perspective from her side. So just an update. Her name is Sanya Reed-Smith. Patrick and I both are speaking to her later this morning. So just an update about it. Sarah, you can go ahead.
Thank you. Good morning to you, sir. I had a question that I think centers maybe around public international law. It's somewhat two-part. The first is, does state recognition, that is the recognition of a state, affect trade? And second is, what happens in the case of goods that are exported from disputed territories or assembled in disputed territories? Think maybe Kosovo, Serbia, or things like that. So how does country of origin marking work then?
Whoa. Honestly, I don't know the answer to that. It's a great question. But I honestly, I don't know. And sorry, the first question was what, Sarah?
First was whether recognition of a state, as in whether it's been internationally recognized as a state, affects trade. So essentially the role that recognition would play, because I know that Palestine, which is not officially recognized as a state, still participates in trade. So what kind of role does that play?
Again, I'm afraid I'm not going to try to make up an answer because I don't know the answer. And I'm really sorry, Sarah, but I wish I could answer it, but that's, I simply don't know the answer. I've never run into this in practice, this kind of issue. And I honestly don't know. Sorry.
Patrick, if I can add something to that. It's not the answer, Sarah, but I just want to give an assurance that there's a fantastic line of speakers that you can reserve your question, and it's such a big area that international trade is. You can ask other people also, and we have people joining us from the bodies like experts in international law, from International Law Commission, or maybe like some foreign policy experts also. So you can reserve your question and can ask them.
Thank you, Manoj. You took me off the hook. Thank you.
No, Patrick. It's a big area.
It's a huge, very interesting question. But yeah, I'm sure other people next week or the week after will have some ideas.
Sure. Sanchit, you can go ahead.
Yeah. Hi. So my question was, earlier I had also asked this question with respect to the bound rate. Sorry.
Mm-hmm.
So in agricultural products, the bound rate is way more than the applied rate, and you mentioned that this maybe this helps the economies domestically. It helps them domestically. But then, as an exporter, does it not increase my risk? Because say if the bound rate is say 60 and if the applied rate is 17 for one country, would that not increase my risk rather than I would go to a country where the difference between the bound rate and the applied rate is way lesser so that my risk is, minimized?
Well, again, a very good question, and I think I understand what you're foreseeing. Now, if let's say you're exporting, Indian companies exporting batteries to the United States, and let's say, well, no, that's a bad example because the U.S. Almost all bound rates. But let's say you're exporting to South Africa, and let's say South Africa, the bound rate on batteries is, let's say, 40%, and the applied rate is 15%. Now, I think what you're suggesting is if you export the batteries, is there a risk that customers will say on that particular shipment, we're going to use the bound rate, we're not going to use the applied rate? I think that's one of the questions you're asking. And the answer is no, because applied rates, all tariffs are set in just about every country by the legislature. I mean, it's a matter of an act of parliament. And you can't just go back and forth from applied rate to bound rate. You would have to say, all right, by act of parliament, we're going to increase the applied rate from 15% to 30%, but it wouldn't apply to existing transactions. Does that help? So, yeah, I mean, there's a risk that, yeah, all right. Well, again, yes, let's look at this. Right, so we got applied rate on batteries of 15%, bound rate at 40%. And you say, well, that's good. We produce batteries much more cheaply. 15% duty, we can deal with that. We can sell over a 15% tariff. We still have enough profit to be able to sell. But so you set up your operation, you set up your factory, and you start exporting. And then the battery industry in South Africa goes to the government and says, hey, we need some help. We're really having trouble. These Indian batteries are underselling us and they're taking away market. Then the Indian government could decide to increase the tariff either to the bound rate or lower. So there is a sort of long-term risk. There isn't a risk in terms of there's also a risk of a safeguard case if you do well, or dumping or counterfeit. I mean, there are always risks involved. The question is, how can you minimize them?
Absolutely. I think that was the answer I was looking for, that it is a long-term risk, basically. I think that answers my question. Thank you, Patrick.
Not at all.
Anyone else? Last 5 minutes for the open session. And if we don't have any question, we can conclude today's sessions.
I want to say again, and I know I've said this several times, but I am very impressed by the level of questions there. You're obviously a very sophisticated audience, and really, really getting into interesting detail. And so I'm, as I said, very impressed.
Well, I'm sure with the passing of days and with the upcoming sessions and tomorrow we have two very interesting sessions, and where Dr. Arthur Appleton, who is a very well-renowned international expert in international trade, and Anuradha RV. She is one of the leading practitioners on international trade and investment in India. So tomorrow we are gonna listen from both the speakers, and I think you can have a lot of great questions for them, because trade and environment. So I'm obviously having questions for both Arthur and Anuradha, and yeah. So if we don't have any question, we can conclude this session. And thank you very much to all of you. I look forward to seeing you virtually tomorrow. Have a good night. Thank you, Patrick. Thank you so much.
Thank you. It's been a pleasure.
Let's connect at 11:30 for our call.
Right.
Great. Thank you. Bye-bye. Bye, guys. Take care.